this evening, rather than my questions being posed to Brian, this is going to be an interactive experience with the members of Beth Shalom through me as the moderator, having their questions answered by Brian. So welcome, Brian, once again to the program. Good to have you.
Good to be here.
All right. So are you ready for these questions? There's some tough ones here, Brian, tougher than mine. No softball.
Go do it.
All right. So the first question was, what was your deciding factor to become a defense lawyer?
Well, I think that, again, it went back to what I talked about the last occasion. I think that both Eddie and my sister and I were all inspired by the legacy of my father, the unfulfilled ambition, not only to be a lawyer, but we always somehow thought that it was so clearly linked to the idea of, Attorney for the Damned and Clarence Darrow and perhaps the romantic-filled notion of the role that the defense played in any justice system. And I think that from a very early age, that was the message that we received and heard, and to some extent, after his death when we were all children, it was his unfulfilled dream, and we hope to fulfill it.
Brian, do your clients who are either found guilty or plead guilty always tell you that they're guilty at the beginning, or is it more?
I think that very often they don't until we're duty bound once there's a resolution or a suggested negotiated settlement of a case by way of guilty plea to either a lesser offense or to an agreed sentence of imprisonment or to even a non-custodial sentence. Whenever we receive an offer, obviously it's our obligation to go to the client and to explain the offer and to explain the risks involved in going forward or accepting the offer. And it's very, very often, it's only when an acceptable offer is made that the client then says, terrific. And when you say, do you appreciate that you're going to have to make admissions that constitute an admission of your guilt, and the fact that you're factually guilty of the offense that was committed, that's when they say, well, I was. And that may be the first time the criminal lawyer actually knows with any level of certainty that their client, in fact, was factually guilty of the offense. Sometimes you know,
Right, let me
at other points. Sometimes you never know.
Brian, let me flip the question around a bit. What about the client who indicates that he or she is guilty from the beginning, but wants to put the prosecution to its proof of the case? In other words, it's not the onus on the defendant, your client, to prove his or her innocence. It's the state's burden to prove their guilt. What are the constraints on a lawyer who has a client says, look, I did it, I'm guilty, but I want to go to trial. I want them to prove the case.
Well, you make the Crown prove its case. You cannot advance anything you know to be untrue. You can't have your client take the stand and speak of innocence or factual innocence. You can't have people provide alibis when you know them to be false. You can't provide any evidence before any court that is not truthful. But again, in most cases, you don't know whether the evidence that you're adducing is truthful or not. You know that that's the evidence that's been presented to you. It is sometimes you say it's quite believable and reliable and trustworthy. Other times you question your own witnesses and say, do you appreciate that this is inconsistent with other facts, with other demonstrable facts, and you're not going to be believed. You want to have sober second thoughts about what you're going to say. But where the client actually makes the admission, again, in virtually all cases, where the client says, I'm guilty, it's usually combined with, I'm guilty, do the best for me that you can. But one of the things of doing the best you can do for a client is every time out, it's the state's obligation, the obligation of the prosecution to prove guilt beyond a reasonable doubt, and you hold them to the strict requisite element of proof.
All right. So Brian, just to set some context for
Are we
my next
frozen?
question, it
Okay.
relates to, no, we're not frozen. Can you hear me? Brian, can you hear me?
I can now hear you again, but you were
Marnie?
interrupted a little bit. Yes, I can.
Yep,
Can
we
you
hear
hear
you.
me?
Okay, okay, good. Yes, I can hear you. It's just Zoom world, Brian. We have to,
Okay.
it's a little bumpy along the way. So
Okay.
my next question,
No problem.
good segue, it deals with Zoom trial. So let me read to you, this is fresh out of the news from today about a case in Texas, all right? A courtroom in Texas is holding what is believed to be the first virtual trial over the video conferencing program Zoom. It's a real trial for a real case, but the court is also using it as an experiment how to conduct legal proceedings during the pandemic. The case, it's a civil case, is a dispute over insurance policy, and there were a number of problems as the case unfolded. During the trial, the judge, Emily Misko, frequently helped jurors with technical issues. In the jury selection part of the trial, several potential jurors had trouble using Zoom. Some jurors spoke without realizing they were muted. Others needed help adjusting their displays. And some, just like now, Brian, disconnected from the call. All glitches that the trial judge had to stop the proceedings to fix. So here's the question now from our synagogue member. How will trials be conducted in the future if they are online, in other words, Zoom? Is that part of the future? And how do you see that changing the landscape of criminal defense for the better or the worse? Brian?
Well, I think that there are certain
Hello?
aspects of our system. Am I not coming out? Hello, I'm talking. I hear you're frozen.
No,
You hear me now?
I can hear you. I can hear you. Yeah,
Do you hear me?
I hear you, Brian. Yeah.
Okay. All right. So
Yes.
I think that
Yeah, go
Just
ahead,
proceed.
Brian.
I
Okay.
hear you, Brian.
I think that there are aspects of the system. Okay. I think there are aspects of our system that will change. I think certainly attendances for without trial, attendances that are administrative in nature. I think that we're set for those to be almost fully either by way of teleconference or video conference. I think motions, many motions that are just before judge alone, those motions can be accommodated again in a video conference setting, and I think without much damage to advocacy and without much damage to the system. But I think cross-examination of witnesses, and I think jury trials, I think that there really would be a tremendously adverse impact on those processes if we went to video conferencing. A great deal of the courtroom drama is drama. It's moving around the courtroom. It's presenting documents to the witness. It's challenging the witness, not only verbally, but challenging the witness in a physical sense by the presentation of documents or the presentation of an exhibit to the witness. Those are not simply a dramatic effect, but it's a part of advocacy that does test the reliability and trustworthiness of a witness. And to do it simply by Zoom and by video conference detracts, I think, from the presence of those personalities in the courtroom. That's one significant aspect. And jury, quite frankly, we were just discussing today the idea that there's been a proposal that a particular tribunal will hear a matter by way of video conference, and the witnesses will be, again, remotely brought into the tribunal room. And we're very concerned about it because the witness and her spouse have given inconsistent statements, and they live in the same place. So if you have the witness and the spouse present at the same time when a video conference is taking place, There's going to be coaching that you won't be able to detect. We'll only see one witness. Where's the spouse? Is the spouse in the kitchen, sort of giving hand signals or putting up notes as to coaching the witness? You'll never be able to see it. So I think to preserve the integrity of the courtroom, I think it's necessary to be live. I think that the cross-examination, examination and cross-examination of witnesses, it's important to preserve that as being a live experience, not a video experience.
Right. I guess the technical glitches is another issue, isn't it, Brian? What about the aspect
Sure.
that Zoom captures the setting that you're in? You know, so if you have, so Brian, go ahead.
No,
Go ahead,
I'm sorry.
Can you hear me?
You froze again. We're experiencing,
Okay.
we're experiencing glitches tonight that are quite significant. And if we experience those in the context of a trial, I think would really undermine the integrity of the whole process.
Right. What about another issue, Brian, which is Zoom captures the setting that you're in. You have a beautiful library office we can see. What if you're someone who's a homeless person who's a witness? Would that impact on the credibility of that witness if he or she was Zooming from their street setting where they reside, as opposed to the affluent witness who has the opulent surroundings? People are human. Those kinds of things make impressions. Do you think that is another potential issue?
I think that is a potential issue, although it may well be that if they were in their tent on the street, it might enhance their credibility rather than detract from it. And the lovely library in the home in Forest Hill or Rosedale might detract from it rather than enhance it. So, I mean, again, what it will play to, unfortunately, is prejudice. And the prejudices as perceived by the trier of fact, whether it be a judge or a jury. It's one of the reasons, and take this as an example, I've always been an advocate of preserving the barrister's gown, because the barrister's gown in the Superior Court, in the Court of Appeal in the Supreme Court of Canada, is a leveler. You don't know whether if you're wearing the expensive clothing that enhances or detracts, but it must do something to the person who sees the person who so appears distinguished because of their clothing, appears to wear their clothing well. The schlub may have a problem, but the gown is the leveler. Everybody is in a black gown with a black vest with tabs, and everyone, again, starts at the same point. They look similarly, and there's no discrimination between anyone based upon the way in which they might dress.
All right. Let's move to an area that I know will be very meaningful
frozen again.
For our members watching. It's a question about hate speech. And Brian, when there's video evidence of hatred, inciting signage, and hateful speech, such as kill the Jews wherever you find them, at public rallies and on university campuses, why don't the police lay charges in those cases for the most part?
Well, they do, in fact. I think that the charges aren't laid when the wrongdoer is anonymous, when you can't locate the wrongdoer. But we have two sections of the criminal code, both of which have been held to be constitutional. One is advocating genocide. So kill the Jews would qualify for the more serious offense of advocating genocide. And then we have inciting hate, which is a more difficult offense. But nevertheless, we're found and where in fact there is evidence of who the identity of the wrongdoer, it's very, very frequently prosecuted. I took a look because I had anticipated this question. I took a look at the 2018 statistics, and in 2018, police reported 1,798 criminal incidents in Canada motivated by hate. That's against all groups. And in 2018, a total of 31% of hate crime incidents were cleared, meaning solved. So first of all, the clearance rate is low because so many of these incidents, vandalism in cemeteries, graffiti on walls, they're anonymous and you can't clear those cases because you don't know who the perpetrators are. That compares to usually a slightly higher percentage of all crime is cleared. About 40% were actually solved by the police of crime generally. But of the 31% of hate crimes that were cleared, 68% of those that were solved, 68% resulted in charges. The other 32% did not resolve in charges, and that compares similarly to the general clearance rates and charges of all crimes generally. It may well be, partially because of the difficulties involved in the section, in order to preserve the constitutionality of the inciting hatred section, there were some provisions put in that create defenses that may be obstacles to conviction. So very often, the repeated voice of hatred, they very often charge criminal harassment as opposed to inciting hatred, simply because criminal harassment is easier to prove. But in another case, you may recall it, and those of you may have read 2 years ago, there was a fellow who, in Kitchener, who was not only inciting hatred, but he directed his attention to the rabbi in Kitchener, Waterloo, Rabbi Zuckerman, a lawyer, Mark Grossman, and another lawyer, William Klein. And interesting, William Klein turned out not to be Jewish, so that the perpetrator of the hate was mistaken when he included Klein. But in his messages, this fellow said Hitler was right. He lauded the final solution and the plan to exterminate Jews. He received a sentence of 18 months from Justice Pokale. So these crimes are in fact prosecuted, and they're, again, more difficult to solve, more difficult to identify the perpetrator. But once someone is identified, they're prosecuted, but generally speaking, by way of criminal harassment, because it's just a charge that's easier to prove.
We should point out too, Brian, that
with me.
if the person is found guilty, the judge is required to take it into account if it's a hate-motivated crime as an aggravating factor on sentence. So
that's right.
Someone wanted to know how far are you willing to travel for a client, Brian? How far are you willing to go? Or I guess the better question is, what's the farthest place you've defended a case?
Well, we're only licensed to practice in Canada, but I've appeared in 7 provinces and 1 territory, and I actually have conducted quite a number of cases in Halifax. I've never done a case in Quebec, and that's intentional. I'm really quite, if I'm bilingual, my second language is Yiddish, not French. So I'm really unilingual in a lawyer's sense in terms of just being an Anglophone. And I've always thought it a disadvantage in Quebec not to speak French in the courtroom. And virtually all of our colleagues, as you know, Steve, in Quebec, and a lot of them are Jewish. When they're in court, they're French speaking. They're not English speaking in the courtroom. So I've never gone to Quebec because of that. But I've appeared in Vancouver. I recently appeared in Calgary. I've appeared in Saskatoon. I've appeared in Winnipeg. And quite frequently in Halifax.
And for extradition
One
cases,
case in St. John.
Sorry, Brian, for extradition cases, you've likely traveled outside Canada. Am I right about that?
Well, I've traveled outside of Canada. As a matter of fact, I had an expedition matter where I had retained Yehuda Weinstein in Tel Aviv, who later became the Attorney General. But Yehuda acted for me with respect to being my Israeli agent on a case there. I very frequently have been in the United States. I've only been called on to actually make submissions in the United States on one matter, and that was in Buffalo. But I certainly was with my fellow counsel, late Jeremiah O'Sullivan in Boston, as I stood by him as he acted on the matter of Alan Eagleson in a Boston courtroom. So I've been on many matters in the United States, but generally speaking, on a non-speaking role. But I did make submissions in Buffalo on one matter.
We spoke last time about your brother Eddie Greenspan, brilliant criminal lawyer, and one of the members wanted to know if you have a favorite Eddie story.
I've got many favorite Eddie stories. Eddie was about, first of all, as funny as you could get, and he was very, very quick, and he very, so frequently had the right word and the right story to tell. But most of those situations were that. They were situational. And humor, as I said on the last occasion, is mainly situational in a courtroom. There's a very funny, and you may have been there, Steve. We have a continuing education series in Toronto called the Garage Series. And Eddie and I did a panel together, or just the two of us. We sat in armchairs, and David Humphrey, my partner, was the moderator. And we did this about 7 or 8 years ago, about 8 years ago, I believe. Eddie passed away 5 years ago. So about 7 or 8 years ago, the two of us are in these armchairs. David's asking questions. And I used as an example an extradition case that I had been on, that in fact Eddie had asked me to do. He had sent me the case. And I said, well, in the case of the United States, America, and Barbu, which, the Court of Appeal recently dismissed my appeal against his extradition, and he's now been surrendered. And all of a sudden, in the middle of it, he stopped and said, "You lost Barbu? I can't believe you lost Barbu. You should have won Barbu. Barbu was a winner. You lost Barbu." Right? And he started hucking me in the middle of this, and there were about 400 lawyers there. Every 15 minutes for the next hour and a half, in the middle of a sentence, he would stop, look at me, and, "I can't believe you lost Barbu. I can't believe it. You lost Barbu. You should have won Barbu." So that's one of and he was just wonderful about it, because everyone, you're on the floor and you have no response to it, because there can be no response to it. But that was always his strength, and always a strength, because he was, I guess, in a boyish sense, that he was always mischievous. He was mischievous, and when we were growing up, he was mischievous. I'm sorry to take this detour, but when I was about the summer after Eddie's first year of university, he started at U of T in 1962. So the summer of 63, he's back in Niagara Falls for his summer job. So he's 19 at the time, I'm 16 at the time. And he turns to our mother and he says, "Ma, can I have the car? I've got a date tonight." First, he's got a date. He doesn't tell her the date's in Toronto. Okay, so he drives to Toronto to pick up the date in Toronto. Around midnight, I get a call, and I pick up the phone quickly. Her mother's asleep, and he says, "You're not going to believe it. I'm at Fran St. Clair, and the car's been stolen." And I say, "Yeah." He says, "Cover for me." So, "What do you mean cover for you?" "Cover for me." So later, 5 hours later, he phones again. the car had been stolen and somebody bashed it into the wall at 999 Queen Street, as it then was, and the car's a wreck. He phones me and says, "Don't tell Mom, cover for me." So again, he was always cover for me, and it was always sort of fun to be around him.
So Brian, we'll
Okay.
move to a serious area, and it's a question relating to sentencing. And one of the members would like to do it. We're frozen. Can you hear me, Brian? Well, it's not my computer. I'm doing the best I can.
Yeah,
so the question, Brian, is relates to sentencing, and the member of our synagogue wants to know why. Why are sentences so light for people convicted of crimes of violence? Would be men, not people. Men convicted of crimes of violence against their spouses and against children. Why are the sentences so light? That's the question. Could you hear me, Brian?
The answer is that the questioner is wrong. The sentences aren't so light. Yeah, can you hear me? Hello, can you hear me? I can hear you. Can you hear me?
Yes, I can. Go ahead. Yes, I can hear you, Brian.
Can you hear me?
Yes, I can. Go ahead.
Okay.
I heard you say the sentences are not so light. Yes, the sentences are not so light. The questioner is wrong.
The answer to the congregant. Yeah. So, and let's take a look at this, because a study was done by University of Toronto's School of Criminology. I think had at that time the retired dean, one of our great criminologists, Tony Doob, Dr. Doob, was then the dean of the school, and he conducted a study, and it was a blind study in some sense. He created various groups, and he provided the facts of a case and sentencing ranges to the variety of groups. And in almost every case, the sentence that the groups of people arrived at were more lenient than the sentence that had actually been imposed by the judge. So given the range of sentence, given the mitigating factors, given the aggravating factors, given the totality of the context in which the offense was committed, generally speaking, the judiciary in Canada is almost demonstrably higher in sentence than the average Canadian would be if the average Canadian imposed that sentence. That group after group have confirmed that almost across the board. So that the problem is that you don't hear all the facts. It's why it's always wrong for people to make assumptions about guilt or innocence based upon a reporter's view of a case. I've read reports of my cases over the course of the last 46 years where I thought that the facts that were presented in the newspaper were unrecognizable in terms of what was actually happening in the courtroom, because it was the reporter's spin, it was the reporter's emphasis. And as a result, most media outlets tend to talk about the aggravating factors without ever touching upon the mitigating factors. What happened, what remedies occurred, what remorse played out, whether this was a first offense, what were the prospects of rehabilitation, what did the psychologists say, what period of time, in fact, had been spent in custody prior to the imposition of sentence. All of those factors are factors that seem hidden. So the positive remains hidden, only the negative is exposed, and therefore the public is misled into believing that the sentence imposed is unduly lenient. If all the facts come out, and if groups of people understand all the facts in the entire context, I'm quite confident that the that the question that was put would be, why are judges so harsh?
Okay, that was very well done, I must say. Brian, they should take, I think, this presentation tonight. Anytime that there's they're considering doing Zoom jury trials, so just watch this to see the glitches that are likely to unfold between witnesses.
Right.
All right, so here's a question. In your career spanning many years, which I am sure is full of surprises, that we know is true, what is something that has surprised you the most? Maybe people, the situation, outcome. What surprised you, Brian?
Well, I can't talk about outcomes being surprises with breaching solicitor-client confidentiality. To say that I expected my client to be convicted, and then surprising, a miracle occurred. And, I recently told my partner David Humphrey that a victory he recently achieved was comparable to the parting of the Red Sea. So sometimes you are surprised by outcomes, and surprised both ways. Sometimes you're convinced that there isn't a basis upon which there can be a conviction, and there's a conviction. Sometimes you're surprised because the evidence seems like there's an avalanche of evidence against your client, and somehow there is an acquittal. So outcomes are difficult to deal with by way of what the biggest surprises are. I think one of the most comforting surprises, although we may be in a period of this being less so, is I think that the collegiality and the commitment of the criminal bar has always been not perhaps a total surprise, but particularly when one compares our bar to civil litigators or others who seem to be more critical of each other, less collegial, committed to perhaps monetary outcomes as opposed to principled outcomes in some fashion. I don't want to be, that's not across the board criticism of other lawyers, but the criminal bar seems a far more united, more committed, more collegial bar because we face the same criticisms from the public. We face the same stress levels in terms of whether or not our clients are going to jail and will be incarcerated, perhaps wrongly so. And so that creates a bond that I think has been something that has been both comforting, but in some ways surprising. And I don't think that the level of commitment has changed. The level of collegiality may have changed, I think only because the size of the bar has grown so geometrically since I was first called.
Brian, the member wants to know the following. I noticed that in some of your famous cases, you don't have a jury. How do you decide if you want a jury for your client's trial?
There are certain cases that are more or less amenable to juries. First of all, if it's a murder case, unless the Crown agrees, you must have a jury. So there are a few situations where there's a mandatory jury unless both sides agree. Murder is the most obvious one. Interesting, in the list of those very few cases where you must have consent of both parties to dispense with the jury, alarming the Queen is one of those offenses. But nevertheless, I'm not sure how you alarm the Queen. But nevertheless, so most homicide cases are jury cases because even if you want judge alone, generally speaking, the Crown won't agree. So that will become a jury trial because the two sides won't agree on getting rid of the jury. In most serious offenses, most indictable offenses, which most people know as felonies, which is the American word for indictable offenses, in most felonies, the accused has the choice. Most commercial crimes are tried without a jury. Generally speaking, if you see a jury in a commercial crime case, that may be indicative of the fact that the case is very strong, and the counsel have come to the conclusion that a judge would, based upon a very strong prosecution case, would almost inevitably convict. So a jury becomes what in football is called the Hail Mary. It's the opportunity to get a verdict that might be less consistent with the overwhelming facts. So that's one area. In violent crime, strangely enough, generally speaking, juries are more frequent because, again, before people are prepared to, because a lot of violent crime very often depends on identification evidence, depends on the proof beyond a reasonable doubt of the involvement and participation of someone in the robbery in which violence was used. In other cases where violence is used, juries are very, very careful and are very, very hesitant to convict. Generally speaking, these days, sexual assault cases are almost exclusively tried by courts composed of a judge without a jury. And that's based upon the fact that judges have to give reasons at the end of the case in order to convict. And in order to convict, they have to very frequently overcome the inconsistencies that exist, the inconsistencies between prior evidence under oath, the inconsistencies between witnesses. And that is an exercise that can sometimes be very difficult in order to come to proof beyond a reasonable doubt.
Okay, Brian, just before I proceed with my next question, I just wanted to make a couple comments to our viewers. I was asked a question to pose to Brian that dealt with one of Brian's specific cases, and I can't do that. That would not be appropriate. We can't talk about our individual cases. So I just want that viewer to know that I'm not ignoring them. I just not able to ask that question. And the second point is that I am getting very good questions. Unfortunately, I have a full plate of questions for Brian. So please, my recommendation is we have another session with John Rosen next week. So please pose those on the Beth Sholem website, and I'll be happy to pose them to John Rosen next Wednesday at 7 o'clock when we have our fourth and final Zoom program. Brian, the next question deals with appeals. And the member asked the following question. We always see the lawyer say that his client is appealing after the lawyer loses the trial. How hard is it to win an appeal? Did you hear that
Well,
question,
for the first
Brian?
decade of my career, yes. And part of the answer is this: I've done not only my share of appeals, I've done probably over 1,000 appeals to the Court of Appeal and Supreme Court of Canada. In the first decade of my career, Eddie was known as the trial Greenspan, and I was the appellate Greenspan, or the appeal Greenspan. In many ways, it can be frustrating, and to some extent, it depends on the composition of the court. And there have been historically different courts approaching criminal appeals with a different attitude. In the first, and I've kind of practiced 46 years, the first 20 years of my practice, not quite 20, we had G. Arthur Martin, probably the greatest criminal defense lawyer and criminal appellate judge that Canada has ever had, and perhaps one of the greatest in the Commonwealth, in the history of the Commonwealth. But Justice Martin, who was elegant and eloquent and very, very kind to counsel, was also someone who would say, "Thank you very much. You were right on ground 1, you were right on ground 3, you were right on ground 6. There were errors on this trial, but nevertheless, the trial, at the end of the day, there was no substantial wrong or miscarriage of justice, and therefore your appeal is dismissed." That was the refuge for about 20 years of how to get rid of an appeal, not grant a new trial, acknowledge the mistakes, and essentially lecture the judges in the trial division as to how they ought to conduct themselves on the next occasion, but it wouldn't necessarily overturn a verdict and lead to a new trial. Generally speaking, you needed quite egregious error before that would occur. There then was the period of time in which there was a really liberal attitude towards the application of the Charter of Rights and Freedoms, starting in the mid to late 80s and into the mid 90s, where a lot of cases where there was a constitutional breach were sent back for new trials because the remedy was to grant a new trial if there had been a violation of the Charter, and sometimes to stay the proceedings. So there was greater appellate success during that period. That period had ended, and we have returned to a period of, I think, conservative and incremental approaches to overturning verdicts. So there is, I don't know what the percentage of successful appeals are. I can assure you it's well under the 50% mark. It's probably even lower than, considerably lower than that. And there was also a time, and this was a historical, it's now an historical anachronism in Ontario, but very often there was a very liberal period of adjusting sentences. That ended by edict of the Supreme Court of Canada, and now you need an error in principle in the sentence before sentences will be reduced. Because again, early in my career, probably for the first 50 years or more, you'd lose a conviction appeal, and Martin would say, however, and thank you very much for your persuasive argument, and we've decided to reduce the sentence by 6 months. It was your payoff for having presented your case well. They'd give, they tinker with the sentence. Well, that occurred for many years. They don't do that anymore. It really has to be quite clearly something where a principle of sentencing law was misapplied or misinterpreted before a sentence will be adjusted.
Yeah, the clear message from your answer, Brian, is you should win a trial, right?
No, no question. No question.
All right. So here's the next question from a member. What happens if you're dealing with a client who is unwilling to cooperate with you? How do you resolve that issue? I guess during the trial, I suppose that's the point. They're not taking instructions, they're not cooperating with you, and yet you're defending them. How do you bridge that problem?
Sometimes you can't, and sometimes it requires you to leave the to seek recusal as counsel. It depends on how bad it gets. The view of most lawyers, both of our generation and the generation before us, was that there were two decisions which were purely the client's decision. Whether to plead guilty or not guilty is the client's decision, not the lawyer's decision. One hopes that the client listens to the lawyer's advice and what risks there are in pleading not guilty when guilt is overwhelming. But the decision to plead guilty or not guilty is the client's decision. The second decision that's the client's decision is if you plead not guilty, whether you take the stand in your own defense is the client's decision, not the lawyer's decision. Once again, listen to the lawyer's advice, but the decision is the client's decision. It's the view of most people in the criminal law that every other decision, the lawyer listens to the client's view, but it's the lawyer's decision in criminal law. So that the notion that you have in civil litigation and in other areas of the law where they say, these are my instructions to you. I want you to do the following. And if you have a true disagreement, then you have no choice but recusal. But instructions are given to the lawyer to act in a particular way in other areas of the law. In criminal law, we're not used to taking instructions. There are only two questions to take instructions on. All the others are, we'll listen to you, and we create the strategic approach to how the defense will be advanced. And if you get into disagreements, if the agreements become too serious, then there may have to be a parting of the ways even in mid-trial if the judge is prepared to let you out. Very often the judge says, you're in this, continue on.
And it's important to note, Brian, isn't it right that if you do have partings of way in the middle of the trial and you have to make the application to the judge, you can't do it in a way that discloses too much about the problem to the judge because you have an obligation to maintain solicitor-client privilege. Is that correct?
You have a continuing duty of loyalty to the client. That's first and foremost. You have to protect privilege, but also your duty of loyalty. So you can't reveal anything that for instance, you've been asked to do something that you view as being unethical or improper. The client says, well, I'm taking the stand and I'm going to lie. And here's what I'm going to say. And I want you to lead me through this and I'm going to tell my story. And the story is untrue. So you have this dilemma. And if you're not relieved of that obligation, then there are ways of approaching it. J.J. Robinette, one of the great lawyers of the century, and who started his career as a criminal lawyer, his approach to that dilemma, there was a great panel when I was a young lawyer, a panel that involved G. Arthur Martin, Charles Dubbin, J.J. Robinette, and Joe Sedgwick, who were the great, and David Humphrey Sr., and they were the greats of their generation. And they were asked, what do you do in that situation where the client insists they're going to lie? Robinette said, if you're not relieved of your obligations counsel, then the client takes the stand and you simply ask one question: can you tell the jury what happened? And you then sit down, and in your closing address, you do not refer to any fact you know to be untrue. So that's why you really do want to be relieved, because doing that in some ways may very, very much undermine the persuasiveness, certainly, of the defense.
Brian, my next question is a COVID pandemic question, and the member wants to know if the province would have the ability to issue a law rather than just a directive or a request for the 6-foot separation order requiring social distancing. In other words, could they legislate the inhibition of our freedom and require us by law to stay 6 feet apart from each other? Would that be something that would be within power of the province?
It's hard. Let me say that they could certainly issue a regulation with a penalty. It would almost certainly be challenged as being an infringement of fundamental principles in terms of freedom of expression, freedom of movement, all of the, it would be challenged. Whether or not it could be sustained, I think would depend on the balancing between the social havoc of that sort of restriction and the risk to public health. It's a really difficult balance, and it's not as if I mean, look at the lockdown was struck down in Wisconsin as being unconstitutional in the United States by 4-3 judgment of an appeal court in Wisconsin. So, and that's just the lockdown generally. It's hard to know which way our courts would go, but whether or not, I mean, do they have the right to create a regulation that's punishable by fines in terms of whether or not you can sit on a park bench? They certainly have the legislative authority. Whether that legislative authority then is superseded or trumped by the Charter of Rights, that's difficult to say one way or the other.
Down to our last two questions, Brian. So the second last question deals with the issue of the wrongfully convicted. And the member asked the following question: what percentage of people in Canada who are prosecuted are actually innocent? I don't know that you can answer that, but you understand the tenor of the question. Do we have
yeah. let me say this. I think that there is certainly, I think that what the statistics generally have been in the last decade is around 80 to 85% of all people charged with a crime plead guilty to something. Not necessarily the charge with which they're originally charged, and if they're charged with multiple counts, it may be either redundant or they're not guilty of the more serious offenses, but guilty of a less serious offense. So that takes care of a large number of the cases. So let's assume, for purposes of that seeking out the statistic, the 15% of people that say I'm not guilty, there are various definitions of innocence. Were they factually guilty of the offense without the necessary and requisite mental element of the offense? That's one feature of it. So you have the right person, but you have the right person who was either acting in self-defense or was under duress or was provoked and for some reason should not be convicted of the offense with which they're charged, or that they're simply factually innocent. You have the wrong person. So that all of those features come into it. How many people are convicted who in fact are factually innocent? I have no idea, but I still would think that it's something more than nominal. It happens, in my view, too frequently. Are there cases where, there's certainly many cases over the course of these years where I've seen people convicted where I thought they ought not to be. That may not mean that they're factually innocent, but it does mean that, in my view, the case wasn't established beyond a reasonable doubt. It's difficult to distinguish between those two situations.
Brian, the final question is mine, moderator's prerogative. Albert Krieger, one of the greatest criminal lawyers in American history, passed away this. It's a tribute question to him. I was lucky enough to hear him speak in the United States at the Criminal Justice Conference. And in a speech in 2008, in part, he said the following: "The criminal defense lawyer marches into the pit, often unloved by everyone in the courtroom." And I think he's absolutely right when he says that. So here's the question. If you walk into that courtroom every time you do a trial, just as Albert Krieger says, unloved by everyone, hopefully not your client, but unloved by everyone, how do you flip that around? How do you turn that around and transform that feeling during the course of the trial so by the end of it, you get the jury to actually like you and get the jury to actually cheer you on to the verdict you're seeking?
Well, I'm not sure you have to be loved. Certainly, it's best that you not be detested.
Yeah,
It's
common ground there. Yeah.
It's best that you not be either someone deserving of criticism. I think in most situations, unless it's called for, you have to be in some ways above the fray. In some ways, you have to be there representing a justice system. You have to be appealing to people's principles, appealing to the morality of not simply the immorality of the allegation, but the morality of your client's position as being someone who deserves due process and a fair trial. So I think you have to elevate the principles. You have to demonstrate to the judge and the jury that this is not a situation that is deserving of anything but sober second thoughts and a serious review of the nature of the investigation, the proof that has been provided by the Crown, the evidence that has been gathered in the course of the investigation, and whether that evidence gathered can lead to some sense of moral certainty that the person is guilty of the offense is charged. you know, there's seldom, although occasionally, there's seldom total exoneration during the course of a trial. It can be vindication. And I think vindication and exoneration are two different concepts. Vindication, I think, takes place when at the end of the day, you arrive at the conclusion that the person ought not to have been charged, not necessarily because they were without some sense of moral guilt, but that there was never enough evidence gathered to satisfy our standard of proof. Exoneration is more by way of the notion of real innocence, that they had the wrong person, that the person acted properly and lawfully, and those situations are less frequent. But vindication, I think you've seen it in your career. I've seen it in the course of my career. Next week, John will answer some questions. John has frequently seen it in his career. The people who ought not to be convicted because the evidence doesn't deserve a finding of guilt beyond a reasonable doubt are people who are vindicated by the system.
So I want to thank you, Brian. The greatest tribute that I can give to Brian Greenspan, because I've known him for many years, is that he's as fine a person as he is a lawyer. So on behalf of the members, the viewers who've watched, Brian, thank you so much of giving of your wisdom, your sage insight into criminal law. We've all benefited from it. And hopefully we'll do something like this. When the technology improves, we'll do it sometime again. Thank you, Brian.
Okay, thank you, Steve.
Erev Tov. Good night, everyone.